When the gavel fell and the nation held its breath, the courtroom was quiet in the way only history-making rooms ever are, not peaceful, watchful. Every breath felt measured. Every movement felt amplified. And when the gavel struck, it did not merely signal order. It announced a collision. "Congresswoman, you will not turn my courtroom into a political theater." The words cut sharply through the air, spoken with authority, with finality. For a moment, it felt as if even the walls of the Washington federal courthouse leaned inward to listen. At the center of that silence stood Jasmine Crockett. She did not sit. She did not flinch. She did not look away. Her posture was calm but resolute, like stone against a rushing current. Her eyes remained fixed forward, not in defiance, but in certainty. "Your Honor," she replied evenly, her voice neither raised nor trembling. "With all due respect, the Constitution does not end at your bench." And in that instant, something changed. This was no longer a routine legal proceeding. This was no longer a procedural disagreement. This had become a moment of reckoning. The gallery froze. Reporters stopped typing. Law students leaned forward as if instinctively aware they were witnessing something that would be studied, debated, and remembered. The Washington Federal Courthouse had seen history before. Its stone corridors carried echoes of landmark rulings, civil rights battles, and constitutional arguments that shaped generations. But this moment felt different. The energy in the room was not just legal, it was moral. Seated high above the chamber was Beryl Howell, a veteran of the federal judiciary. Known for discipline, efficiency, and an uncompromising view of courtroom decorum, she represented the institutional weight of the robe itself. For decades, attorneys had entered her courtroom knowing interruptions would be swift and tolerance thin. To many, she symbolized the authority of the system, order over emotion, procedure over passion. Across from her stood someone forged in a very different arena. Crockett was not shaped by elite detachment, but by grassroots legal battles, civil rights cases, and communities where the law was not theoretical. It was survival. At 42, she carried the urgency of a generation that had watched democracy strained, bent, and tested in real time. The case before the court centered on newly passed election laws, restrictions on early voting, mail-in ballots, and identification requirements. Supporters called it security. Critics called it suppression. To the court, it was statutory interpretation. To Crockett, it was the soul of democracy. As she began to speak, she carried more than notes and precedent. She carried the voices of voters turned away, communities sidelined, and rights narrowed by design. "These measures," she said, measured but firm, "do not protect democracy. They weaken it." A ripple moved through the gallery. The judge leaned forward. "This court does not entertain political speeches. Focus on the law." The interruption was sharp, unmistakable. But Crockett did not retreat. She cited precedent. She referenced constitutional protections. She grounded every argument in legal doctrine. Again, the interruption came. "This is a courtroom, not a history lecture." The tension thickened. Observers exchanged glances. Civil rights attorneys recognized the tone, not unfamiliar, but charged. Still, Crockett pressed on. She spoke of equal protection. She spoke of the 14th Amendment. She spoke of voting not as a privilege, but as a constitutional right safeguarded through struggle. And then, the gavel struck again. "Enough!" The command echoed. "I will not allow this courtroom to become political theater." Silence followed, not empty silence, but heavy silence, the kind that precedes consequence. It was here, in that pause, that Crockett stood taller. "Your Honor," she said again, calm but unwavering, "the Constitution does not end at your bench." And with those words, the battle lines were drawn. When authority was challenged by principle, the silence after her words was not ordinary silence. It was alive. For a heartbeat, no one moved. No one spoke. The air itself seemed suspended, as if waiting to see which force would assert itself next, authority or conviction. The judge remained still, gavel clenched in hand. "Congresswoman," she said sharply, "you will confine yourself to legal precedent, or you will be held in contempt." The threat was clear. But Crockett did not step back. She stepped forward. "I am presenting precedent, Your Honor," she replied. Brown versus Board of Education. Harper versus Virginia Board of Elections. Reynolds versus Sims. Names that carried weight. Names that reshaped America. These cases, she continued, establish that what some dismiss as politics is, in fact, constitutional law. A collective inhale swept the gallery. Phones lit up. Pens flew across notebooks. This was no longer an exchange. It was a confrontation. When constitutional arguments are dismissed as talking points, Crockett said, her voice sharpening, the law is not protected. It is diminished. The judge rose from the bench. You will not lecture this court. Crockett raised her hand, not aggressively, not disrespectfully, but firmly. Respectfully, Your Honor, she said. I am not lecturing. I am reminding. The room gasped. A reminder of history. A reminder of balance. A reminder that no institution exists above the Constitution. She continued, measured but powerful. Article 1 of the Constitution establishes the branch of government I serve in. It created the framework under which this judiciary exists. Her words landed with precision. That authority does not place any court above the Constitution. It binds us all to it. No one spoke. For nearly half a minute, the courtroom existed in a suspended state, where everyone understood they were witnessing a moment that would not fade. And when the silence broke, it broke everywhere at once. Reporters rushed out. Social media ignited. Headlines formed in real time. The Constitution does not end at your bench. The phrase traveled faster than the gavel ever could. The fallout begins. By nightfall, the confrontation was everywhere. Television panels replayed the exchange. Legal analysts paused mid-sentence, visibly shaken by what they had witnessed. Civil rights organizations responded immediately. Statements poured in praising Crockett's composure, preparation, and constitutional clarity. Law professors called it a masterclass in advocacy under pressure. Meanwhile, scrutiny turned sharply toward the bench. Judicial ethicists questioned whether repeated interruptions cross a line from management into dismissal. Within days, complaints reached federal oversight bodies, not demanding punishment, but demanding reflection. Inside legal circles, the conversation was quieter, but more serious. Temperament, judicial humility, the line between authority and arrogance. Crockett, meanwhile, returned to Capitol Hill unchanged, except in one way. She was now heard differently. In hearings, her questions landed harder. Her presence commanded space. And when witnesses tried to evade, she reminded them calmly, I have already explained constitutional law to a federal judge. I will not be intimidated here. That line went viral too, that a movement finds its voice. Civil rights groups seized a moment. Fundraising surged. Volunteer lists grew. Training modules replayed Crockett's words. Universities added the confrontation to curricula. Mock trials mirrored the exchange. Students studied not just what she said, but how she said it. Calm, prepared, unyielding. Across America, debates ignited. Some criticized her boldness. Others called it necessary courage. But no one ignored it. For a public exhausted by noise, this moment brought clarity. It wasn't spectacle. It was civics in real time, why this moment will not fade. Beyond America's borders, the world watched. Some saw division. Others saw resilience. What they witnessed was democracy confronting itself, openly, imperfectly, honestly. At the center stood symbolism impossible to ignore. A black woman, a federal courtroom, a constitution invoked not as tradition, but as promise. This was not rebellion. It was remembrance, a reminder that democracy survives not because institutions exist, but because people defend them, and that defense does not always arrive politely. Sometimes it arrives calmly, prepared, unapologetic. The Constitution does not end at your bench. Those words will echo long after the gavel's sound fades. The question now is not what happened that day. The question is what happens next. Will courage like that become common or remain rare? That answer does not belong to courts or Congress alone. It belongs to the people. And as long as people remember that the Constitution belongs to them, it remains alive,